All right, talking about the openings. And openings come after the jury has been selected and is sworn. They're seated and the court will advise the plaintiff's attorney to start. Plaintiff's attorney starts because the party with the burden of proof always goes first, and the party that has the burden of proof always gets to go last. So they would do the closing last. They'd get to speak to the jury last. And opening statements are generally introductory. That is, you would be giving people what would be sort of a quick movie review. In today's case, you're going to hear from 5 witnesses. Our case is about contract dispute. The witnesses are going to be 3 employees of the company who were present when the arrangements were made. We'll also have you look at the contract, and we'll also have you look at certain inspectors that have determined that the job wasn't done properly. Something along those lines. The defense will make their own opening statement, again, probably touting what to expect, what to look for, and how you'll present these certain witnesses. Then at that point in time, the witnesses will start to be called and they'll testify. So first, the case will start with what we call direct examination. That's where the plaintiff will speak to their own witnesses and lead them through a series of questions. I use the word lead advisedly. In other words, you're not supposed to ask leading questions. You're supposed to ask questions that are 5 W's or an H. That's who, what, why, where, when, or how. So any question that starts with that phrase, who, or what, or why, where, when, how, all of those kinds of questions are going to be appropriate. And the idea is that with the questioning, you want the information to come from the witness. The attorney shouldn't be providing it. There will be evidence. Evidence will be introduced. Generally, a physical item will be marked for identification, so it'll be Exhibit 1. The evidence will need to be relevant. That is, it has to have some bearing on the issues that are involved in the case for it to be admitted into evidence. It also can't be unduly prejudicial. So that means it's not so dramatic as to offend the jury. For an example, sometimes very awful photographs in criminal cases that show severe injuries are often deemed too prejudicial to introduce into evidence. There are different types of evidence. There's direct evidence, that is, you were at a location and you saw Bob take the magic markers. That's direct evidence. You saw that happen. There's also such a thing known as circumstantial evidence. Circumstantial evidence might be called indirect evidence. That is, it's evidence that needs to have what we call a logical inference. Logical inference. Common example would be that if you woke up in the morning and there were footsteps outside your window that came up to your window in the snow and then away, you would be able to logically infer that someone walked through the snow up to your window and walked away. Much evidence admitted into cases is circumstantial evidence, and again, you have to have that logical inference. The exhibits that get introduced will usually be, as I said, actual physical evidence. That is, if there's a knife or a gun or anything like that, that'll be introduced. Oftentimes there'll be issues about what we call chain of custody. In other words, what we call authentication. That means that if we show the jury a pack of magic markers, we need to be able to authenticate it. That is, we need someone to be able to say that this was the magic marker that I found on Bad Bob's desk on the day in question, and it was confiscated and kept in this envelope until this very day, or until times it was examined and we resealed it. And that's the chain of custody. That's that it's authentic. Sometimes you'll have documents that need to be authenticated. If you wrote a letter to someone, if they wanted to introduce that into evidence, they probably wouldn't be able to, because it wouldn't be their words, it would be your words, and it would be your writing. So you'd have to authenticate it. They'd have to call you to the witness stand. They'd have to show you your writing. You'd have to identify it as such, and you'd have to indicate you had written it. At times, there are official documents. For instance, if you wanted to get a copy of someone's driver's license or a property deed or what have you, those can be self-authenticating. You'd check with a particular statute to see whether that item being sent to you with a seal on it would be properly authenticated. So in every case, you wouldn't have to get the director of transportation to come to your courtroom. They could just simply send you a copy of a driver's license with a signed statement that says, this is the real thing, this is what we found. So that's authentication, and some documents, many documents, are self-authenticating. Any state records are generally self-authenticating. Demonstrative evidence. This is kind of a fun part of law, and I've been involved in a couple of things that were interesting. One involved a case where a person was charged with having shot his wife. He claimed he'd bumped a dresser, and a gun that he was transporting from the attic to the basement had discharged from bumping into a bureau. And when they went through it in the courtroom, the gun, of course, was not loaded, but when they bumped it against the bureau, it did fire. That the hammer did it fired is, I guess, what we'd have to say, but no ammunition in it. But demonstrative is any demonstration within the courtroom to depict an effect or an occurrence that may have happened. So once the evidence from a particular witness is complete, then we use cross-examination. And I will stop at this point and start another session for cross-examination. Thanks for listening.